The way I worked with that was to use the texts and papers available in the 1980s. And in order to do that, which I didn't share with you in the report, was I basically spent a week at the National Fire Academy in their learning center, their library, and reviewed all the texts and some of the journals that were magazines that were available in the 80s to, develop an understanding of what was being taught, what were the reference materials saying at the time. And I want to point out that, that I regard that as a standard of care. There's another concept of what's normative. And certainly there can be differences between what's the norm and what's the standard. We have a situation where, people may normally not be doing the standard of care. And obviously that's even harder to deal with, but I want to bring out that difference. I provided you recently an executive summary of the report. I haven't changed my opinions in the year and a half since I wrote the report. But I have, in talking to a lot of people, found that it might be useful to boil it down to something shorter, so I did that. I think the biggest problems with regard to satisfying the standard of care today in both these cases are their failure to eliminate all accidental/natural causes. The source of that as a standard of care is included in a large number of references of the day. They're on page 4 of my report. That's sort of the overarching methodology involved in fire investigation of the day. You asked about how that changed over time. Obviously, what changed over time was the introduction of NFP 921, which is the scientific method is the methodology rather than eliminating other causes. So that's a change in the procedure. Eliminating causes is an inherent part of both of those processes. How those are structured and disciplined, how structured they are different. But the notion of eliminating all other causes is common to both. Other standard of care issue that I saw with these investigations was either not taking any eyewitness testimony or doing any interviewing, or when they were done, ignoring them, or coming to conclusions that were inconsistent with them. And that's basically a timeless thing. I mean, think back in your own mind in forensic science when the use of interviewing and testimony of eyewitnesses wasn't part of what was done. In my lifetime, it's always been done. So I don't see that as something that's actually changed. It was embraced then as an important method of collecting data that's relevant to fire investigations, and it is today. The third thing is more indicator-oriented. These investigators, by their own admission, in their reports, in their testimony, trial testimony, understood that many of the indicators they're using, in particular the low burn damage, the patterns of the floor, they recognized at the time that arson, spillage of a large quantity of accelerant, which they opined in these instances, was not uniquely the only way that could occur. They understood that at the time. Yet, they used that piece of evidence as that means it's arson, when by their own admission they didn't know that, because they could not exclude other means, accidental means, by which that pattern could have been created. So, rather than going any more detail, I'll leave it at that and look forward to answering your questions.
Well, we asked Lance to head up the development of these questions and coordination, so I'll pass that over to you, Lance.
All right, thank you. And what I'd like to do is, I believe that we were able to give you in advance some questions, and I think that you tried to answer some of those in the executive summary that you gave us. I may go back and touch on some things, but obviously I'm not the only one with questions, so when I do that, then we'll shift over to whoever else on the commission has some questions. I noticed that we've got two folks that are just now arriving, and we really want to let them come on in and have a seat. This is good because we won't have to repeat anything later.
That works. I get a copy?
I think I'm going to go ahead and get started. And these were questions that were compiled with the input of several of the commissioners. If I step on anybody's toes and throw out the questions, I apologize, because in the interest of time, we'll get on. And again, some of this I know that you commented on. But just give us a brief summary, if you could. You don't have to go over everything that you did in your executive summary. Let me just start with this. In the original report that you submitted to the commission, you stated two different things. Number one, you stated, and I think you're in agreement with a lot of the experts, that there was no one scientific reliable standard of care. If I use the wrong terminology or my phrasing is not accurate, please come back and correct me. There was no one scientifically reliable standard of care in arson investigation back at that time period, 1989, 1991. So it was hard to pinpoint whether a uniform standard of care was violated. And yet, you stated later in the same report that, in your opinion, that there had been, was the word negligence, that there was, it did not rise to the level that it needed to. Can you just real briefly summarize your explanation for that? Because I think that that has given some of the commissioners a little bit of trouble.
Sure. It is correct to say 921, consensus document, clearly bought into by the whole community, eventually, not initially. And so that, yes, post 921 is pretty easy. Before 921, we do have things like the National Fire Academy, who's charged with teaching fire investigation for the nation. That is, they have courses, they bring people from all the different states into Emmitsburg, Maryland, teach them with the intention of them going out and doing further teaching, of people in their areas. And that's how our system of education, the fire service, is largely orchestrated. Obviously, the states and locales are doing their things as well, but it actually starts from a national organization and moves down through that and works at all levels of government, like things do in the fire service. So, I mean, one can look at what materials they were using, and as the report indicates, that for most of this period, their curricula are basically following Kirk's. And they have supplementary material and other ways of talking about it and what have you. So obviously, I think that's an important point in terms of understanding where the community is at, because that's the leadership position in all this, and brings together some form of consensus nationally as to how this enterprise of educating fire investigators need to be going. You notice also that I shy away relatively from saying anything about how definitive the standard of care was on any particular fire indicator, because that was all over the place. And I think in that particular issue, you can't read books or look at how courses have been taught and come to a clear conclusion that everybody agreed on that. You can agree on the fact that there's plenty of warnings that many of those indicators aren't reliable. Warnings, as in, don't rely on this solely kind of information. And our investigators in these cases acknowledge that they were not regarded at the time as being uniquely indicative of use of large quantities of accelerant, for instance. So when the investigators themselves and this broader literature, were in general agreement about something, That sounds like a standard of care to me. Obviously, any of those determinations with a lack of a consensus document is subject to judgments. And I made my judgments. And obviously, it's your job, I presume, to make your judgments and, use mine simply as a guide to where you may go with that. Some things haven't changed that much. I mean, as I indicated, how eyewitness interviewing and stuff. I mean, it may be better codified in some sense, but the role of interviewing in fire investigations, has been and will continue to be, an important and valued element.
I guess I'm not hearing a very clear answer to Lance's question. I think pretty uniformly within the commission, in reading your report, commissioners did identify the contradiction that Lance was talking about. You state pretty clearly that there was not a standard of care, and we use different phrases, standard of practice, we're all talking about the same thing. There was not a standard of practice for fire investigation, particularly in Texas during the time period of this investigation, that was identifiable. And by that, I'm assuming you're using generically the whole investigative process. You certainly identified that there may have been specific parts of the investigation that were more finely tuned than others, but in general, there was not a standard of practice. And yet, later on in your report and in your executive summary, even more clearly, you contradict that by saying that they violated the standard of practice. And I'm very much interested in a clear answer to Lance's question.
Yes, thank you for that. We all can easily agree that a codified, written, standard of care, single document, 921 style, did not exist at the time. Okay, the broad brush. There isn't a single document that says what everybody thought they should be doing, what all the teachers thought they should be teaching. Stipulate that didn't exist. We're clear about that.
Yeah, and I think that's uniform with the other opinions that we got as well.
So, does that mean that a standard does not exist? No, I mean, there are elements of what people did that everybody agreed on, whether they bothered to sit in a room together and come to some consensus as to where it was and then write it down.
And that's what you're referring to when you talk about this national research that you did.
Well, the research, it's national in scope to the extent the textbooks are certainly not local, yes.
Did you do any research to identify what the Texas, a state standard practice was?
I did not identify anything that I didn't come to Texas and do research here, I will say, but I haven't identified anything that indicates to me that there is a varying standard of care on a national basis because of the educational system that has been in place.
But it would be fair to say then that you did not specifically research anything in Texas.
With regard to standard of care in particular, that's unique to Texas. That is fair. That is entirely fair.
Some of these other individuals had more familiarity with the Texas standard of practice and came to the conclusion that even looking at that there was not a uniform standard of practice, either a written one or one that was put together by word of mouth. Do you have any reason to think that their familiarity with that Texas practice would be better than yours?
I'm not aware of the documents that you're referring to.
I think that helped clarify our question. I appreciate it.
Give me your thoughts on national versus state standard. I mean, certainly we have to look at what fire investigators were being taught in Texas by different agencies that are in charge of training. Do you have any opinions or thoughts on to what level or what extent the folks in charge of that training or the agencies involved in Texas should look to national standards or national materials that are available in helping to develop local standards, or do you think that they should just be totally separate? It's kind of a vague question. I just want your opinion, your thoughts on it.
there is no reason to expect that one state's standards should be different than another state's. I mean, we all aspire to do as best we can. And since the legal systems that we work in are quite similar, not identical, but quite similar, and you know, obviously the knowledge base that we all work from is the same, and the educational resources are national, if not international in scope. I see no reason why there, you know, would be or should be a local standard of care that's distinct and different from one that would be applicable to broader jurisdictions.
But wouldn't it be fair to say that we've come to a consensus on that opinion much more in a more modern fire investigator view than perhaps in the late 1980s, early 1990s?
The process of initiating the development of NFPA 921 has been of great value to the fire investigation community. It has pulled together in a single room, you know, dozens of people who are experts in that field, brought input from far more people, brought a level of consensus, you know, that's not readily achievable in any other way. Individual book authors obviously are familiar with all of the information that's out there as best that they can individually do that. And they, in their teaching and writing, are attempting to, you know, reflect, you know, the broadest and best enunciation of the fire investigation art and science. But clearly NFP 921, getting people in a room, putting a document on the street, getting comments, proposals through a public, you know, process, you know, has been invaluable to the community.
Going back to the original question about the lack of existence of a uniform standard and your comments that even though no such uniform standard existed,
It's documented in a single place.
was documented at the time, yet you still found some real issues with that. Maybe it would be instructive for you to give us a couple of examples of things that you uncovered in your report that caused you to come to that conclusion, if there are major ones that stick out in your mind. I guess just by way of example, and kind of following up on what Mr. Bradley was asking about.
Well, I mean, in my view, the most important ones I've tried to touch on. The overall methodology of, if you're going to call this arson, you have to eliminate all accidental and natural causes. You know, that is something that I believe is a standard. It's not a documented standard, but it is our common understanding among educators and practitioners that that is how you make a determination that arson has occurred. You know, you have to eliminate all accidental and natural causes. That's not a new thing. The way we go about that is somewhat different in the 80s versus, you know, in current world, i.e. scientific method versus, you know, eliminating alternate causes. But that principle is fairly timeless and, you know, accepted, I think, generally. And that, you know, I think that's how it becomes the standard, is by developing a general consensus in the community that this is how investigations are to be done. Similarly, I mean, the use of eyewitness information. I mean, it has never been okay in fire investigation to go in, spend a couple hours on a fire scene, poke around, look around, leave, write a report, and never talk to anybody. I mean, interviewing first responders, interviewing eyewitnesses, and dealing with what they have to say has always been a part of fire investigation and forensic investigation far more broadly than that. And that's, I mean, you know, do you need that to be written down in 921 to understand that? Well, I think not, you know. So, you know, and with regard to the pattern stuff and the indicator stuff is far more difficult. It's more problematic because there are, you know, at the time, there were people who said this pattern means this and it didn't, and other people who understood that it didn't. The consensus, the concurrence of opinions about that was developing during the 80s. And I would not have if the only things wrong with the investigations was that these investigators believed that this pattern uniquely meant something that it didn't mean at the time. If that's all that was wrong, I would not have said they violated the standard of care, because there were, at that time, sizable numbers of people who believed that these floor patterns meant it had to be accelerant-based and had to have occurred that way. They're wrong, but it was, an understanding that a sizable number of people had, and I would not, have that rise to the level of, a standard when that lack of consensus, is apparent. Now, here I see those pattern issues as a problem nonetheless, because we have investigators who acknowledged that they were not unique. Now that changes a lot. I mean, if these guys thought and believed that this pattern means this, can't mean anything else, we can talk about that. But when they acknowledge that they are not unique, but use them as the means to determine that this must be arson and not ruling out accidental causes, it's linked to the need to rule out accidental causes. If it's not uniquely arson-based, pattern, then there are the potential for accidental causes that can cause that pattern, and hence you don't know. And the right thing for an investigator to do under the circumstances of I have more than one cause is undetermined. I don't know. That's a legitimate finding.
The other questions that I have right in front of me, I believe, were questions that were submitted to you in advance. I think that they were contributed by other members. And I believe that you may have touched on some or all of this in your response. But what I would do is ask those members here if they're satisfied with any written documents in response to those questions that the doctor has given us, or do you want to follow up with specific questions?
The two investigators, you acknowledged, or they acknowledged, that there were other explanations for the pattern. They knew that. Where would they have learned that?
From
Coming back to standard of care, and where would they have been able to acquire that knowledge?
They acquired that knowledge ultimately from textbooks, reference books that said, here are these kinds of patterns. They may mean this, but they may not. And how did that arise? I mean, it gives rise to an interesting question of how at the time was this knowledge developed? And it is sadly the case that in the run-up, call it up to the 80s, because obviously research takes time to get into practice, that there was no coherent research programs in forensic in pattern recognition and indicators and the general art and science of fire investigation. Most of what was known was individual investigators on an opportunistic basis having the opportunity to experiment or draw from things that they had done to come to an understanding of, ooh, I once thought this pattern meant something, and based on this training exercise, I saw that on the floor and there was no arson. Or, actually having the opportunity to do it in a more formal scientific setting. But, I mean, the profession was bootstrapping itself at the time. It understood that it was behind. I mean, as I indicated in one of the paper that I provided to you more recently, it was the case that in the 70s, fire investigators were being more exposed to fire science and fire scientists, because in large loss fires, and both property and lives, in the 70s and going into the 80s, fire scientists, fire protection engineers were being used by attorneys in lawsuits. And the investigation community were working alongside them. And they're looking over and saying, wow, look at this stuff. I should be using this. And the astute members of the investigation committee in the 70s were seeing this and starting to read fire protection engineering books and fire science books, bringing that to their practice, bringing it to their writing, and beginning the process of integrating what was known based on fire science into the art and science of fire investigation. None of the things that we're talking about here is the actual fire science is the limiting reagent. Fire science has been ahead and known most of what we need to know to answer most of these questions long before you could say there was a standard. And it's really what has happened in the fire investigation community is a growth process in the sense of recognizing this resource of fire science that's a formal discipline that did have funding, that did have a national research focus, that was learning things based on science, that we can use that as a resource, bring it over and build our profession in a way that will help us. That's, I would generally say that starts in the 70s. I can't say it didn't happen before that, but it certainly got legs in the 70s and then proceeded from there. And so that's how up through the 80s, knowledge with regard to indicators was developed in the fire investigation community. And it's a little bit, it's better now in the sense that there is some national funding for research in fire investigation. It's not huge. The National Research Council has, made its opinions known on the need for more in a broader sense in forensic sciences, and fire investigation certainly no exception.
So would it be safe to assume that they have been exposed at some time to the concept that the pattern may or may not reflect use of an accelerant?
Yes.
Given their conclusions and their statements and their testimony that they recognize these patterns may be caused by something else.
Yes, I think it's extremely significant that they themselves admitted that. Yes.
Can you offer, Beyler, your opinion, your position on the origin and spread of the fire based on your review?
Cause undetermined in both cases. In the Willis case, I have a fairly poorly developed understanding of the area of origin. Living room, dining room is the best that I can say based on what I've seen. In the Willingham case, the room of origin is the child's bedroom. Beyond that, I couldn't say. And I think we all need to recognize that areas of origin start large and get small as the quality information improves. And the ability to go from undetermined to determined in terms of cause, improves as more data, is brought to bear. And we can't do any better than the data that was collected on the day.
Dr. Beyler, having reviewed the documents, what evidence do you find that would support a fire investigator at the time reaching a conclusion that this fire was arson? And would that opinion have been the same in 1991 and also in 2004 when the fire was, the documents were re-examined by other experts?
I'm going to ask you to restate the question, I'm sorry.
So based on the documents that you've reviewed to date on the Willingham case.
On the Willingham, okay.
On the Willingham case, what evidence is there to support a finding of arson by a fire investigator in 1991?
What evidence do we have, that they have then, and that they could have recognized or that we can recognize now that points to arson as the cause of the fire?
Would you support their conclusion based on information that was available in 1991?
No, based on what was available at the time, this is an undetermined, the cause is undetermined. There's no way that you were going to determine the cause based on what they knew at the time. There's no way.
And by undetermined, you're not excluding arson.
Well, no, I mean undetermined. I mean I mean it like I mean it, yes.
Well, I say that because the media sometimes takes that answer and turns it into there was not arson. And would it be inaccurate for the media to report that your conclusion is that there was no arson?
You are correct. I have not come to the conclusion that neither of these fires were or could have been arson.
But my question is, would it be incorrect for the media to report it that way?
Yes.
You have not said that.
No, I haven't said that.
So just to clarify then, as time went on, as that fire science developed, and as standards of practice improved over the years, would I be correct in assuming then that later on, after 1991, you'd have the same opinion, that there still wouldn't be sufficient evidence to corroborate a finding of arson? It would still be undetermined?
I mean, it's even more strongly the case as time moves along.
Right, I just wanted to clarify.
Right, yeah. There's no question that as time moves along, the support for the determination that these were arson fires gets less and less, not more and more.
Well, that may or may not be true. There can be new information that could cause you to conclude that it was an arson, couldn't it?
Hypothetically, yes, and now we're talking about in the Willingham case. In the Willingham case.
And I'll give you an example. I recall a couple of years ago that when the governor's mansion burned down, there's a lot of people jumping in front of TV cameras speculating about what the cause of the fire was. It's always an interesting subject.
Something new in the world, yes.
And there was one individual who proclaimed himself to be an expert, who in great detail explained why it was an accidental fire. And on camera, continued to explain why that was an accidental fire. As it happens, that individual is the same person who has offered his opinions on the Willingham case. That would be Gerald Hurst. But his opinion, I guess, by now has changed, because after he concluded all of that with all the information that he had, the security video from that was located, and it showed somebody with a Molotov cocktail throwing that into the building. Now that kind of information, if you were in that individual's position, would probably change your opinion, wouldn't it?
It is always the case that when any of us write a report based on the information available now, and that's what you can work with. And if there are instances, I don't think it's the case in Willingham, but in other cases it may be, when new evidence comes to light, new evidence should be examined and opinions can change. And I don't think there's any investigator who wouldn't agree that give me new data, I'll reevaluate it, and I could change my mind. That's why we collect data, because it helps.
Well, and I suspect that's why you and other careful experts don't rashly proclaim that something was an accident when there's insufficient information to show that, and why your opinion today, and continues to be based on Dr. Kerrigan's question, continues to be undetermined. And perhaps Mr. Hurst should have been more cautious, as he said, undetermined as well, so that he had room to change it once the facts revealed that someone threw a Molotov cocktail.
Well, we can talk about, how useful it is to, make, rash proclamations of a cause of a fire. Obviously, what we do as a profession is work with the data we have, formulate findings, and those are potentially subject to change. Does that mean, because there might be new data later, mean we should refrain from making determinations? Well, I think not. But should we do it rashly? Of course not.
Well, and you've had some experience with that yourself here in Texas, haven't you? Wasn't there a case that went all the way to the Texas Supreme Court in which you acted as an expert and you testified, I don't know, you didn't testify, I think it was, you did this by affidavit, I think, in which there was a summary judgment. And your opinion was that it was a fire that was caused by a halogen lamp in a room. And the other side obviously did not agree with that. And the Texas Supreme Court criticized you, I think, pretty seriously because the record, the evidence actually showed that there had never been a halogen lamp proved to be within the case. Therefore, it was unreasonable for you to be offering an opinion that a halogen lamp did that. I'm not here to get into the details of that, but to point out that...
I see that.
I want to point out that looking back at people with a lack of information can be dangerous, can't it?
Yeah, there was data, there was information that indicated that there was a halogen leak.
We can disagree about that. The Texas Supreme Court wrote an opinion that disagreed with you. My point is, I like your opinion. I'm not quibbling with your opinion. I want to make it clear that your opinion is one of undetermined, at a 20-year hindsight. And I'm assuming that you're not in great dispute, you have some details of the dispute, that these people did the job that they did, working as best they could with the standards as they existed at that time.
I think we'll differ on that.
Thank you.
Dr. Beyler, I wanted to explore your recommendation of undetermined a little bit more. And let me throw in the way I look at it. I am a forensic pathologist, and I have a case. It's a lady that died of a drug overdose. And I can't decide if the drug levels by themselves are a drug overdose or a suicide. And therefore I call it undetermined. Whereas there's a person on whom I do all the studies, if there are no drugs, there's nothing there for me to pinpoint what the person died. I call it undetermined. So when you say undetermined, what precisely do you mean? Are you trying to tell us there is no evidence, or there is evidence, but you can't decide if this is accidental or arson?
Typically, it's a multiplicity of hypotheses or causes that are consistent with the case facts and what we know about fire.
In this particular case, which sort of undetermined is you are tilting towards? Is it a case, in this Willingham case, whether there is no evidence to suggest anything, or there is evidence to suggest this could be accidental fire or could be arson? Is that what undetermined means?
Undetermined in this instance, let's go with the Willingham case. On the stand, the investigators acknowledged that there were other potential causes that they could not eliminate.
Such as what?
The two that were brought up were child fire setting, and the other was an intruder. And they said that they couldn't exclude those.
I think they said it was possible.
Well, that's what it means to not be able to exclude it. It's possible. That's what it means.
But what are the likelihoods of those two things actually being explanations?
That is not part of the discipline of fire investigation in the 80s, and it isn't now.
But it might be something the jury could do.
We're not here, I'm not here to talk about what juries should do. Not something I'm here to talk about. I'm here to talk about fire investigation, and probabilities are not a part of.
So the only two unexcluded causes that you're specifying are that a child did it and that an intruder came in and set a fire.
Those are the two that they acknowledged.
Well, they were asked specifically, is it possible? Is it completely possible for those things to occur?
They acknowledged that those were two possible causes, that they were possible. That meaning, in my parlance, cannot be excluded, cannot be eliminated.
But in their parlance, weren't they very clear though that they thought that those two scenarios, given their understanding of all the facts, were extremely unlikely scenarios?
Fires are unlikely scenarios. It's unimportant whether they regarded them as highly unlikely or not. The discipline is elimination or not. That is, they are inconsistent with the case data, they are inconsistent with what we know about fire, or they're not. You could argue that we should be doing fire investigation on risk basis, probabilistic basis. Maybe that someday will be the way fire investigation is done. I doubt it, but that's never been the methodology of fire investigation. It's one of eliminating causes to come with a unique cause that's consistent with what we know.
Other than
And imperfect knowledge at that.
Other than the defense attorney speculating that those two scenarios happened, did you find any evidence whatsoever in the case to support that an intruder came in and set that fire?
No, I can see that we're trying to conflate what they were willing to acknowledge with what exists. I mean, the room of origin in the Willingham case was shoveled out the window, and the pile of debris was never examined. Well, how can you eliminate accidental causes if you're not going to even look at the remains of the contents of the room? It's not going to happen. I bring up what they acknowledge because, frankly, what they acknowledge is sufficient. The fact is that in their investigations, there were things that they didn't do that should have been done, which would, have allowed, the determination of the efficacy of other potential hypotheses that they didn't even bother with. So it's, you have to eliminate all causes. Once they've admitted they haven't, we're done. Does that mean they did everything else right? No, it doesn't. But it also means that we don't need to focus on it either.
Thank you.
Let me ask a clarifying question. You're talking about the two possibilities that they acknowledge. Is what you're saying, though, that those two possibilities, you have to assume a hypothetical that it was definitely arson, or definitely a fire that was started by someone. You're just trying to figure out who that was that started. Or are you including, I mean, there's other explanations besides a human being starting a fire. Is that accurate?
I mean, as a general principle, yes.
All right,
Yeah, those are just two examples that came up in the context of testimony.
Did you feel like an electrical cause of the fire was ruled out in their investigation? Did you feel like maybe they should have had an expert come in and look at the electrical system and see if there was any problem?
Yeah. Certainly, the documentation of the electrical examination was poor. I mean, all you get is, I looked at the wiring and it was fine. I mean, and obviously, no one can second guess you when that's all you do. And is that okay from an investigative point of view? No, that's not okay. When you shovel out a room and put it in a pile outside the window and don't examine it, how can you say that you've examined the electrical system? Because we have electricity in the walls for a reason, to power things in the room. And you didn't include in the electrical system, any of the electrical appliances in the room. So, I mean, how can you say that you eliminate all electrical causes when you didn't even look at them all?
So you spoke to them about that and confirmed that?
It was in the materials that you provided.
Did you speak to them?
Oh, no, I did not speak to any of the individual investigators. I did not think that appropriate under the circumstances.
What would be inappropriate about it?
It would be inconsistent with the charge that your commission provided me.
Did we ever tell you you couldn't speak to them?
I don't recall. I don't know that it came up.
Well, what I'm hearing earlier is that you say that in any legitimate investigation, the person is going to go out and talk to as many people as possible. What would be inappropriate about talking to the very people you are attempting to express an opinion about their work?
No, it wasn't what I was asked to do.
Well, you're the person who can tell us if you need to do it as an expert. Why didn't you ask us?
I think we can determine what we need from the record. I mean, I don't feel like I'm not able to make the determination that I made based on the record.
Wouldn't you have more confidence if you talked to the person who was actually there and did it?
There is no downside to that. There is no downside
All right, thank you.
from an investigative point of view.
Right, that's all.
There are a couple of things that you were concerned with and you have raised several times in your reports. One of them was that according to the fire marshal, he had investigated something like 1,200 and 1,500 arson cases, and the majority of them were arson. And that really bothered me. There were a couple of other statements that nearly half the people in the fire died in the fire. And finally,
I'm sorry, what was the second one?
50% of people in the fire died. Mortality in the fire is 50%.
I don't know that to be correct, and I don't think I would have written it.
No, the fire marshal is stated during the trial.
Gotcha.
The third thing is that he opined about the injury patterns, and he suggested that the injuries that Willingham had sustained could not have been accidental. So could you say a little
Well, I think
more
what he
about-
said was they were self-inflicted to confuse the investigators. That he self-inflicted injuries to make it appear that he had been, a mere victim.
So do fire marshals normally opine about injury patterns and suggest whether they're accidental or self-inflicted?
Are we talking now or then, or both?
Then and now?
Then and now, okay. Certainly, if you're doing a fire investigation now, an autopsy is something you will want to look at if there's a fatality. You will be interested in carboxyhemoglobins, you'll be interested in extent of burns, you'll be interested in, potential presence of alcohol, drugs, what have you. So from that point of view, using information that comes out of an autopsy, quite generally, utilized by fire investigators. Making judgments themselves about this guy couldn't have been exposed, didn't have a smoke inhalation because, a number of days later he doesn't have trouble talking. That's out of bounds. I mean, that's just an individual guy making conclusions based on his own personal experience that isn't science at all.
Members, I think given the number of people we have to talk today, we set aside about an hour for each one, and we're well within that right now. I just want to give you an idea of where we're trying to taste this. And so we've got about 10 minutes on Dr. Beyler. Do you have a question?
I have a question. Is it possible to determine accelerant use based entirely on a visual examination at a scene rather than chemical testing? And feel free to answer that within the context of the case information for Willingham.
Certainly at the current time, the presence of an accelerant is only establishable based on 921 or standard of care. If a sample is taken and the determination is made using analytical chemistry. That's it. Nothing else works. Other field techniques, there's sniffers, there's your nose, there's dogs, there's other things that are field methods. They are there to assist you in taking a sample so that the analytical chemist can do his work and it has a sample that's likely to, to be the appropriate sample to determine. But it's the analytical chemist that is the one who can make that determination ultimately. At the time, the determination that an accelerant was used was not that narrow. This is an area where I think there was an evolving standard that some people, the textbooks were at the point of saying it'd be a really good idea if you did the analytical chemistry, but at the time I don't think they were saying you have to do it or else, or if the analytical chemistry comes back, no, it's not, I think that was something that was in flux.
And specifically, there was chemical testing in this case. Can you talk a little bit about the chemical testing that was done, not the methodology? And I'm an analytical chemist for the record, so it's good to know I have a job. But the type of testing that was done and the fact that there was, in fact, a positive finding and I believe some negative findings. Can you address that?
Right, we're doing Willingham again.
Willingham,
Yes.
yeah.
So in Willingham, I don't recall the number of samples that were taken, there was a positive for medium petroleum distillate, I believe, or kerosene, something of that nature, at an area at the front door. That was accepted by the investigators as indicative of the use of an accelerant. And my problem with that in this instance is that the front porch had material that was consistent with that and containers that were there and damaged. So it remained to be determined that it wasn't that material. Or clearly that material could be used by a person, as an accelerant, but that remains something that the analytical chemist doesn't tell you that. They tell you what it is.
But the chemical testing that was conducted on other items of evidence removed from other parts of the residence, presumably, was negative.
They were.
But that negative finding, I assume you would agree, is not a conclusion that there were no accelerants in the house.
I mean,
In other words, the accelerants can be burned up.
it is possible to have accelerants used and not find them.
That's all.
That is the case.
And doesn't it also depend on how quickly that evidence is collected? I mean, after all, when you're looking for accelerants, you're looking for volatile substances, and if the evidence has been in place for a while, essentially there can be nothing left.
Right, timeliness, methods, this business of, I guess, primarily in Willis, of washing the floors first. I mean, help me. I mean, how can you possibly hope to find anything after that? I mean,
Dr. Beyler, I just want to make sure I understand you well. What you are testifying today is that you are not saying that this is not an arson. What you're basically saying is that this is an undetermined cause of fire, and it is undetermined because there is insufficient evidence to show that this could have been due to natural causes or accidental fire. And this is because of investigative flaws. Is that what you're saying?
well, there certainly are investigative flaws, but we can only make statements about the investigation that was done, right? And if you have a bad investigation, the likelihood of being able to sustain a single cause and exclusion of all others obviously goes down. The better the investigation is, the more likely you will be able to identify one and only one. But the investigator is entitled only to say this is an arson fire after he has gone through the process of eliminating all accidental causes. Having not done that, having acknowledged not doing that, he's not entitled or allowed to proclaim that this is an arson fire. That's an inappropriate professional action. When you have not eliminated the accidental causes or alternate causes, you professionally cannot say it's arson or it's whatever cause you might think it is. Because then it's just, at that point, it's just your personal feelings. And that's not what our profession is about.
But supposing he had excluded natural causes and accidental causes, could he then by exclusion call it arson, or he said that's a true arson?
The latter part, please?
I mean, just because you exclude natural causes or accidental causes of fire, does it automatically mean that this is an arson? Isn't it a burden on the investigator to prove that it is an arson?
Well, that is an area which has changed. I think that in the 80s, people did determine that it's arson because it wasn't accidental and it wasn't natural. Today, no. Today, with the scientific method, you have to show that your proposed cause, and you can't just say arson, it's got to be specific, is consistent with all the case data and is consistent with our knowledge of fire science uniquely. That it is consistent with what we know, everything we know, and everything else is inconsistent with what we know, then you're entitled. That has changed over time.
One thing that probably hasn't changed is ultimately when you offer a conclusion, wouldn't you agree that you are offering an opinion?
In the context of court, you are certainly offering an opinion.
Okay. And would you agree that two qualified experts looking at the same information can hypothetically come to opposite conclusions?
It happened.
And in fact, it happened in that case with you before the Texas Supreme Court. I don't recall who your expert on the other side was, but I'm assuming he had an opinion, an expert opinion, that contradicted yours, didn't it?
It is normally the case in fire cases that when the experts on either side agree, those cases go away. It is only the instances where that disagreement persists, or at least there's someone who persists in that, that the need for formal trials goes forward.
Right, because then someone, a fact finder, has to still evaluate the credibility of the two opinions and come to a conclusion about which one they find to be more reliable.
And in addition to the judge making his determinations as a gatekeeper rule.
Right. And that doesn't mean that one of those experts was negligent and the other one was not negligent, does it?
Simply that they disagree is not in and of itself, in the abstract, determination of lack of conformance with the standard of care.
Right, and we're not
If
here.
I can
Go ahead.
follow up on that.
Yeah.
There are judgments that are made. If you have an eyewitness and who says something, investigators make judgments about the quality of the information that they're receiving. And individuals can differ in their findings about what an eyewitness's testimony means.
Okay, and that's a real good example, because there is a lot of subjectivity to the credibility of that witness, to the detail that they provided, and one investigator may give something more weight than another investigator. And you would agree that even under the modern standard, there's a range within which different fire science experts can form different opinions.
That's true.
And so when the Supreme Court ruled against you in that case, they were not saying that, they were not saying that you were incompetent. They were not saying that you were negligent. They were saying that these two experts had different opinions, and we judge this other expert to be correct in this particular case. Would that be a fair summary of that?
I'm not sure it's a fair summary of that instance, but it's a correct hypothetical that happens.
All right, thanks.
Dr. Beyler, pertaining to this two experts differing in their opinion, how can you expect a liberal arts major, with probably a judge in a court, decide which testimony is better, which evidence is better, and which opinion is better? How can you expect a judge to decide that? Should there be another expert saying that instead of a judge?
Yes. In one of the documents that I recently provided you with, I spoke to that conundrum to some extent. Judges are entitled to make use of their own experts, and almost never do. As you say, a liberal arts major, for the most part, not to say all judges are liberal arts majors, that's not true. But certainly, judges are asked to make judgments over remarkably broad areas of science, engineering, and other technologies. And they would be well served to make use of their ability to hire their own experts.
We've reached 10:30. I don't want to cut anybody off. We can come back to Dr. Beyler later on.
One
Go
quick
ahead.
question. You talked about a great deal in the report and in some of the other expert reports that we have access to about the lack of specificity with some of the visual indicators of arson, patterns, things of that nature. In the Willis and Willingham cases, there was quite a bit of overlap in terms of those visual indicators, is that correct?
Yes.
Are there any differences that we should be aware of? Because clearly those cases had very different outcomes, but if I review the visual indicators and some of the sort of scene investigation from Willis, it's somewhat similar to Willingham, and correct me if I'm wrong. So can you elaborate on what those differences are and how that might have had such different outcomes? I mean, is there a scientific explanation for why that happened?
Why?
Why they had such different outcomes?
No, I would not say that the different outcomes with regard to the judicial system are rooted in fire science.
So the indicators in those two cases, the observations that were made by the fire investigators are quite similar.
Yeah, they're relying on these floor patterns as indicating mass use of massive amounts of accelerant. That's not well founded in fire science. I will offer up, because you opened the door to it, there are certainly differences between these two cases. You know, some specifics are very, very much the same, some are somewhat different. I personally don't see how one could make the determination that one met the standard of care and the other one didn't. They're sufficiently similar in the mistakes that they made that I don't personally see how one could make a differentiation between the two in that regard.
Thank you very much, Dr. Beyler.
Thank you.
Next, hear from John DeHaan.